Okay, first matter up this morning, People versus Nicole Aiken, case number 216192. I should have counsel figure chances on the record.
Thank you. I'm for the record, my call on behalf of the people. Good morning, Your Honor. Gary Deagle on behalf of the defendant.
Ms. Aiken is not here in the courtroom this morning, and has she attempted to contact you in any way, Mr. Kilo?
Yes, we made contact with her and told her that she had to go take her forensic examination. And if she didn't do that, there'd be a bench warrant issued and she would be detained until we could get the examination. We haven't heard from her since.
Okay, do you remember when that contact was?
Oh, yeah. It was on 10/1/10/24.
Okay, Mr. Rolla, unless the people have any objection based on Ms. Aiken's failure to appear today, and from what I can tell, failure to appear for examination, issuing a bench warrant for her arrest.
Yes, Your Honor.
So once she's arrested, the court will order that her bond be revoked and that she be held without bond, so that we can have those examinations taken care of. Mr. Roll, anything further on that file?
No, yes.
Mr. Kilo?
Nothing further. Thank you.
Thank you. People versus Scott Grissinger, case number 236670.
The record, Your Honor, from the people. The record, Gary Deagle on behalf of Mr. Grissinger.
Mr. Grissinger present? Okay, you can come forward, please. Mr. Grissinger, you can be seated with Mr. Kilo there. This is Mr. Kilo, your motion to dismiss. I had a chance to review your motion and the brief, as well as your response to Mr. Rolla's reply. And obviously, Mr. Rolla, I did have a chance to review your response as well. Mr. Gilo, is there anything that you wanted to state for oral argument today in support of your motion?
Well, I think the briefs that were filed are self-explanatory, Judge. We don't have a basis to charge him with a felony. At most, we might be able to charge him with a misdemeanor, which would be a retail theft for the one item that he in fact picked out and gave to the person who was supposed to pay for it, left the store with it. My client wasn't involved with any removal of the items out of the store, and I think the court has a basis to dismiss this case. Thank you.
Thank you, Mr. Rolla.
Thank you, Your Honor. A couple things, and I do have both the officer here as well as Homeland Security who can testify to the fact, or prepared to testify to the facts that not only was Mr. Grissinger observed coming in with those people, with all four people, but he assisted in removing items from the shelves. He assisted in putting them in the carts. He turned the carts over to his, if you will, immediate co-defendant. And she then turned the property over to the other two individuals. As regards to the defendant's counsel, Mr. Grissinger had nothing to do with removing the property from the store. As the court's well aware, that's not required under the law. It requires asportation, in other words, movement of the property with the intent to take it. You don't even actually have to take it beyond the registers, although that becomes a matter of proof. I'd further indicate to the court that it does not matter whether the defendant denies his involvement. He was observed by Walmart security, loss prevention, and it's on video if the court would care to view it, regarding his assistance not only in first bringing all four parties to Walmart, going in with them, dividing into two groups, getting the merchandise as I already indicated, then going back to his vehicle where one of the other individuals met him specifically at his car. And then they waited for the two other co-defendants to join them. And of course, the defendant admitted that as to one of the other co-defendants, he told them, we have to get out of here because Walmart wants to arrest us, wants to bring charges for shoplifting. And then the defendant takes them away. It's a situation, quite frankly, Judge, where the simple denial of a defendant, as is attempted to be claimed here, sufficient grounds to grant a dismissal, then it would render the the theory of aiding and abetting null and void, contrary specifically to the canons of construction. Additionally, we're not even at the circumstance of a JNOV circumstance where the court, when the jury is able to hear the evidence and the court can say no rational trial of fact could find the defendant guilty on this. We're not even to that element. We're only to the lower element that this should be presented to the jury. And to not belabor the point, whether or not the defendant did this in concert with the other is a fact question to be decided by the jury, with all due respect to your honor. I mean, I'm not saying you can't rule on the motion. I'm just saying that it's clear that this would be a fact question. For all of those reasons, unless the court wants to view the video and hear the testimony of Walmart security and the officer involved, I have nothing further to add other than what's already been indicated in the briefs.
Okay, thank you. Mr. Gilo, anything in response since it's your motion?
No.
Okay. Again, I did review the briefs, taking those into account as well as the arguments of the parties here today. I mean, I view this as an argument regarding the sufficiency of the evidence and whether or not the people can prove one of the elements, in particular, the amount that's alleged that's stolen. And so the court's role at this stage would be just to determine whether there's sufficient evidence for this to go to trial. In other words, kind of a probable cause determination. I did review the file prior to the hearing today, and I know that the preliminary exam was waived. I'm not sure what the reason for that was, but in my view, this motion puts the court in a position of kind of the district court judge, where I think in order to make an evidentiary finding, I would have to review the evidence as Mr. Rolla suggested and hear testimony. And to me, that's something that would have and perhaps should have been part of a preliminary exam in this case, and then an argument made to the district court judge that it shouldn't be found over because there isn't enough evidence brought forward. And so, I don't think it's a good precedent, and I don't think there's any court rule or statute that would allow this court to have the defendant waive the preliminary exam and then have this court kind of sit by motion to dismiss, sit as a district court judge reviewing the sufficiency of the evidence to determine whether there's enough to go to trial in this matter. So I think from a procedural standpoint, it's improper, and the court is going to deny the motion because, again, it would require the court to sit as a fact finder, and we're not at that stage yet. I do think if this goes to trial, that this motion would absolutely be appropriate as a motion for a directed verdict. And depending on how the testimony comes out, the prosecutor may or may not be able to provide enough evidence. And I think the defense may have a good argument, again, on a motion for a directed verdict. But at this point, the court isn't in a position to find that there isn't enough evidence to go to trial when the defense waived the preliminary exam. So the motion's denied. And Mr. Gilo, if you could provide an order to the
Your Honor, I've already prepared an order. If you want me to.
Can you have Mr. Gilo look at that?
I'll get that
form? Any objection to the form? Okay.
May I approach, Judge?
Yes.
Then I'll have copies made after it's been filed with the clerk's office.
Do we have any other dates set in this case yet?
Looks like there's a jury status conference on April 3rd at 9 o'clock.
Okay.
That's the next hearing.
Okay, so the next hearing is April 3rd, so we'll proceed further. I'm just gonna put that right.
Oh, okay, very good, Judge. I just didn't want to be accused of not getting into the clerk's office.
So we'll proceed further on April 3rd. Between now and then, Mr. Kissinger, please stay in touch with Mr. Gilo. Okay.
Yes, Your Honor.
Mr. Rolla, anything further on this file today?
Not in this file, thank you, Your Honor.
Mr. Gilo?
Nothing further, thank you.
Thank you. You're free to go, Mr. Kissinger. Mr. Truce, I know we're a little bit ahead. Have you seen Mr. Federica yet this morning?
I have not, but I wouldn't think I spoke to him yesterday.
So we'll take a brief recess and we'll go back on the record in about 5 minutes. Okay, we'll go on the record in People versus Cameron Badurka. This is case number 236662. Council can put your appearances on.
Thank you. Thank you, Your Honor. Richard Church hearing on behalf of Mr. Bedurka.
This was set for 9:30, or I'm sorry, 9:15. It's now 9:30. We had any contact with Mr. Badurka.
Your Honor, I will say I'm surprised he's not here. I spoke with him yesterday about this case. I went over the PSI with him about a week ago. I spoke to him yesterday. Actually, he just messaged me back now. He said he's about 5 minutes away.
Okay.
And again, when I spoke to him yesterday, his last message was, "You've explained everything to me. I'm ready to go." So I don't know if something occurred this morning that was a problem for him, but it sounds like he's on his way.
All right, we'll find out once he gets here. And then we're contacting Alpena for Mr. Evans.
Would indicate Ms. Davis is here. I know it's early on her case. And I don't know if the victim's rights advocate expected anyone to be here, victim-wise to speak. I know written statements were submitted.
I think we probably should wait until the time of.
Understood.
To make sure on that one. So. Okay, well, take another break until we have customers. Right, Mr. Evans, are you able to hear me okay?
Yes, Your Honor.
Thank you. All right, we're on the record now in People versus Jason Evans. Two files, case number 216127 and 236554. The record should reflect Mr. Evans is present today by video from Alpena County Jail. If I could have counsel put your appearances on.
Thank you, Judge, for the record, my phone got people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Evans for both the 21 file and the 23 file.
Thank you. Mr. Trush, we do have trial set to proceed, I believe later this month in the older file, the 2-1 file. How do you want to proceed today?
So, Your Honor, I'd like to talk about each files separately. So in regard to the 21 file, we're set for trial later this month. We're prepared to proceed to trial on that. I would indicate to the court, the prosecutor did make a global offer to us. It's not our intentions to accept that. In regard to the 21 case, to be frank to the court, I haven't really expected a resolution. I think both sides think they have a good case that they can be successful with, and those are the types of cases that tend to go to trial. So in regards to that, we're prepared for that trial. I already have subpoenas out. I think we're ready to go on that.
Okay, Mr. Rolla, will people be ready to proceed?
Yes, Judge.
Okay. That trial does have priority. I believe it's the only one scheduled for those days. So from the court's perspective, there's no reason why the court would not be able to go forward. And so Mr. Rolla, if you can prepare a writ, have Mr. Evans transported for the days of trial. Mr. Trush, have you made arrangements for Mr. Evans in terms of street clothes so that he is dressed appropriately?
So I have been in discussions with his sister. I think the issue is taken care of, but ultimately we will make sure that's done.
Okay. All right.
I do just want to indicate to the court, I don't think it affects the trial, but I am scheduled for a district court trial. I think on day 2 of our trial. This takes priority over that, I believe, but again, just to make the record.
Yeah, and let me know if I need to contact Judge Cooper, but this trial needs to go.
I would agree. It's Judge Burmeister.
Oh, Judge Burmeister. Okay, great. I'm sure he'd be willing to accommodate, make sure that you're available, given the posture of this file. All right. So we'll plan on going forward on the morning of the 25th with jury selection and trial in the 2-1 file, and then in the other file. How did you want to proceed?
So, Your Honor, I wanted to create a little bit of a record on this front. Again, we are in receipt of a global offer on these. I'm cautiously optimistic that we may actually be able to come to a resolution in this file. Ultimately, my ask is going to be for the court to set another conference for us at the beginning of April. I think we have dates at the end of April for a trial. Those are stacked with another jury trial, both of which, at least in my mind, are fairly high priority in terms of going for different reasons. But I think that they're both very, they're trials that I think have high priority. With that in mind, I do want to give the court a little bit of a timeline update. So I did just receive the discovery file from Mr. Pfeiffer on this. It was last Friday when I received it. I have had an opportunity to go through this and get myself up to speed. I'm sorry, not last Friday, the Friday before last. When I received it, I've had an opportunity to go through and get up to speed. There are some things that are missing that still need to be done. I'm cautiously optimistic that we'll be in a position to try the case in April, but I do want that status conference just in case I can't. I would indicate again, there's 3 things that Mr. Evans identified to me that we're looking for. One of them, we already have a subpoena out for the information. The other, I'm set up to talk to the trooper in charge of that today to hopefully get that information this evening. And then once all that's compiled, I think we're going to be able to go to the prosecutor and make a counter proposal. We may or may not have a resolution, but I do have some reservations that will be prepared to proceed in April. And I think Mr. Evans is likely going to agree with the sentiment that this information is valuable for the case. I don't think he's going to want to proceed without it.
Okay, so, all right, Mr. Rolla, any input from the people as to, how you want to proceed?
No, Judge.
Okay, all right, that sounds reasonable. So as to the 23 file, to the extent we do have any trial dates, the court will leave those on for now. We'll set this for a status conference at the court's motion day in April. Mr. Rolla, if you can prepare a writ for Mr. Evans by video for that date. And then we'll see where we're at. We'll have tried the other case, and that may affect also how each side wants to go forward from there. Mr. Trush, anything else that we need to address on either file today?
No, I don't believe so.
Mr. Rolla?
No, thank you, Judge.
Mr. Evans, do you have any questions about how we're going to proceed on each of your cases?
No, Your Honor, but I was wondering if I could get a breakout room with Mr. Truce if he has the time.
We're not going to be able to do that now. He's got a number of cases on the docket this morning, so, but I'm sure he'll be in touch with you, correct, Mr. Trush?
Yeah, so I'll contact the jail and we'll get a Zoom call set up. It probably won't happen till next week, it's my guess, but we should be able to do that next week, okay?
Okay.
All right, thank you. That's all for today. The court's going to disconnect at this time. Hold on to the one that's going down. Okay, People versus Erica Bynum, case number 24667.
Thank you, Your Honor. Richard Trish on behalf of Ms. Bynum.
Right, the record should reflect Ms. Bynum's present here in the courtroom today. This is the date and time set for sentencing in this matter. Ms. Bynum, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor, I have.
Okay. Mr. Trush, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
All right, Mr. Rolla, do the people have any additions, deletions, or corrections?
No challenges as to the smoke.
Anything on behalf of the people for allocation today?
Thank you, Your Honor. This is the second felony situation, the guidelines, of course, well, where 017 out of 10. But this defendant has a significant history of absconding, especially look under C item 1 of 3 of adult history record. He has an attempted murder in Texas. Apparently that arose out of his recommendation of 85 days with 85 days credit. And there may be a request for 7411, but we would indicate to the court that people would object to that. Is this the second high severity felony? And I don't believe that the 7411 statute, which as the court's well aware is designed for younger first offenders, is applicable in this particular case, especially with her history. As this was an offense that was committed while on apparently on probation. Thank you, Ryan.
Thank you, Mr. Church.
Thank you, Your Honor. So a few things that I want to address sort of right off the bat. Obviously, there is a significant piece to her criminal history, and that is, adult history, 1 of 3 as the prosecutor identified. But I think even just looking at the little amount of information that's contained within that adult history record tells the court some significant information. I mean, frankly, she was initially charged in 2007 with murder, and that is ultimately resolved with a count of aggravated assault with a weapon. And I mean, I think that the court can probably surmise that there's more to that story if she receives such a generous offer on a charge that was initially charged as murder. To make that even more apparent, at the time, she's given the ability to have a diversion, a 10-year diversion, which she completes 9 of the 10 years without incident. She does have a hiccup in that last year. She fails to report, and she's violated, and she ultimately winds up serving prison as a result of that. None of that is disputed by her. I mean, she acknowledges all of that. I would indicate to the court, again, I think that history probably tells the court there's more than sort of meets the face on that. With that in mind, the circumstances of Ms. Bynum's history are frankly tragic. Essentially, from the time she's born, she has instability in her home, moving around a lot. I mean, she describes her childhood as basically being a gypsy. This continues until she winds up in Ohio at age 10, where her father is murdered. She indicates to me that she observed her mother to do this. Charges were never pressed out of that. Ultimately, she winds up in the foster care system at age 10 in Ohio. She's abducted from the foster care system by her mother and taken to Texas, where her mother ultimately winds up in prison, and then she winds up in the Texas foster care system. She remains in the foster care system until she reaches adulthood, where frankly the charge, the murder charge, appears on her criminal history. The circumstances behind that she describes to me are she witnesses her sister's boyfriend choking her. And this triggers her with the traumatic past that she's had. And again, she accepted responsibility for her actions then. She served her sentence and you know, she resolved that. I say all that because that sort of leads us to when she's done with that, she winds up here in Michigan. She's living in Lansing and she's homeless. She comes into contact with the co-defendant in this case, Mr. Wolf, who finds her in Lansing and approaches her and propositions her to have sex for money. She declines that, but ultimately she does wind up accepting his offer for a room for shelter because she's homeless. She puts herself in a position, frankly, to wind up here in front of the court, and she does. She's in this room with him. She knows what's going on in there. She's not dumb. She sees everything that's happening, and there's drugs in the room. Again, she sees all the signs and knows that. She ultimately accepts responsibility for that. What I would suggest to the court, though, is I don't think that the recommendation here is inappropriate. 85 days in jail with credit for the 85 days that she served would certainly seem within the realm of reasonable outcomes. I would suggest to the court, though, that given the traumatic past that she's had, and I'm sorry, she also has diagnosed mental health issues. She suffers from dissociative identity disorder, which hardly can be surprising given the traumatic past. I would suggest to the court that giving her an opportunity on 7411, which I would disagree with the prosecutor that there's an age element to it. I mean, I think it's for first offenders on drug cases. There's nothing that suggests that it's only for younger people. I think it's just for first offenders on drug cases, which she is. I would suggest to the court that giving her that opportunity would be appropriate. I think it is in society's best interest for her to be monitored and make sure that she's following through on the mental health treatment that she needs. And frankly, that she hasn't been getting the quantum of care I think she needs in the jail. So for those reasons, I think it's appropriate not to impose additional jail at this point. I would suggest to the court, given her background, that giving her an opportunity for the diversion is not only in her best interest, but I think it's society's best interest to try to help her to address some of these mental health issues. And again, having the supervision of the court while she's doing that, I think increases the probability not only that she's successful with it, but the follow through. Thank you.
All right, thank you. Ms. Bynum, was there anything that you wanted to say?
Yes, I wrote something for the neighborhood. So, Your Honor, I want to apologize for the situation I got myself into, tangled up in. I was homeless at the time and I got myself wrapped up with a bad guy and made poor decisions. I have learned from my mistakes.
Thank you. I read through the report, so I'm familiar with what happened in the circumstance and also familiar with your background and circumstances. And looking at the situation as a whole, I don't think your role in the drug issue was as significant as the person that you were with. And I don't have any reason to disbelieve the circumstances as Mr. Trush has laid them out in terms of how you ended up here and with that individual and what your involvement was. Sure, your past history plays a part in what the recommendations are and what your sentencing guidelines are. But I also recognize that that was quite a while ago and really completely unrelated to the type of offense that you're before the court on here. Given the fact that you don't have any real ties to this community, I don't know that probation is appropriate, and I don't think that it's something that is going to be beneficial either for the community or for you in context of this case. So the court is not going to place you on probation. Frankly, I think that may be more negative consequences for you than positive ones. I do think that the recommendation is appropriate given your involvement in this case. I think 85 days is an adequate consequence to you, and I don't think more jail time is necessary to account for your conduct in this case. So I think the recommendation is appropriate, and the court's going to follow that. The court will sentence you to 85 days in the Otsego County Jail with credit for 85 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. You have the ability to seek an appeal of this sentence. Mr. Trush is going to give you some papers that explain to you how to appeal if you wanted to do that.
Your Honor.
Good luck going forward.
Do you have all of them copies? Or just?
Versus Bedurka, case number 236662. Mr. Bedurka present.
Yes, Your Honor. Thank you, Your Honor. Richard Trush, on behalf of Mr. Bedurka.
Mr. Bedurka, your hearing was scheduled for 9:15. Why were you not here at 9:15?
Alarm did not go off. I raced here just to leave. I'm so sorry about that.
Well, you're not off to a real good start.
I know, sir.
I'm about to put you on probation, and you're going to be required to report and do some things as part of your probation. And if you can't make it here to court on time, set your alarm on time.
I said it didn't go off, or I don't know what happened, honestly, sir. I'm too sorry.
Yeah, well, you need to make sure that whatever alarms you need to set to make sure that you comply with your probation, that you do that.
Yes, sir. Yes, sir.
Have you had an opportunity to speak with the lawyer about this pre-sentence report and go
Yes,
through
sir.
that with him? Yeah,
Yes.
all right. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, does people have any additions, deletions, or corrections?
No additions, deletions, or corrections, Judge, nor challenge says, thank you.
Anything on behalf of the people for allocution?
Judge, this is a possession of analogs case and unlawful use of license plates. There's a recommendation of probation of 1 year. I don't think people have any objection to that circumstance, as well as the other fines, costs, etc. in regards to this matter. Guidelines are 0 to 3.
Mr. Trush.
Thank you, Your Honor. I'm not going to belabor the point on this too much. Mr. Bedurka is young. He has very limited prior history before this. I think the PSI here, identifies things adequately and accurately. I think he is a good candidate for 7411. Obviously, there's huge benefits to him of that. Like I told the court earlier, I was surprised Mr. Bedurka wasn't here. I've had good communication with him throughout the case. I would tell the court, I don't think this is reflective of him, what the court saw this morning. I'm hopeful that he will do well on probation. We would just ask the court to follow the recommendation.
Thank you. Mr. Bedurka, anything that you wanted to say?
I just want to say I'm so sorry for being late. Sorry about everything I did. I promise that I won't ever be late or do any of this stuff again.
All right, I read through the report. I'm familiar with what happened in this circumstance. You don't really have much of a criminal history at all, one minor blip as a juvenile, but otherwise, you haven't really been in any trouble. So I do think you're a good candidate for probation. And the court's gonna give you an opportunity to avoid serving any jail time by complying with your probation. But I am gonna hold some jail over your head, hold it in abeyance, so that if you do violate your probation in some way, you're gonna immediately have to report to jail and begin serving jail time. So it's gonna be really important, number one, that you understand all the conditions of your probation, and number two, that you follow all of those conditions throughout the next year. So the court is gonna place you on probation for a period of 12 months. The court's gonna adopt as the conditions of your probation all the terms and conditions listed in the report. Some of the most important ones, of course, are that you comply with any drug testing that's ordered by your probation agent, that you not be in possession of or use any controlled substances or any drug paraphernalia, that you not be with any people who are in possession of those kind of items. The court is going to require that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60 and a $68 state cost. Court is going to impose 90 days in the Otsego County Jail with credit for 1 day served. Court's going to hold that time in abeyance to be served at the discretion of the court. You will be required also to pay a $30 supervision fee per month while you're on probation. All of that is as to count 1, the possession of analogs. As to count 3, the unlawful use of registration plates, a fine of $100 and a $50 state cost. Court is going to make your probation pursuant to 7411. So I'm sure, as Mr. Trush has indicated to you, if you successfully complete your probation, then this conviction would not be part of the public record. So there's, in addition to avoiding jail, that's a significant benefit to you as well. So, Ms. Davis, do you want him to meet with you before he leaves court here? Okay. Because this is pursuant to 7411, there are no appellate rights at this time. Mr. Rowlett, anything further? Mr. Church.
Nothing further, thank you.
Mr. Durka, good luck to you going forward. And Mr. Trush, we're going to move Mr. Cecil's case to the afternoon, is that correct?
I would appreciate that. And just to make a brief record, I was in communication with him yesterday. I spoke to him over the last 2 weeks pretty extensively. During the conversation yesterday, it became very apparent that he did not realize he had court today. This isn't something that we can handle via Zoom, because one of the conditions of the plea we expect him to tender today is that he pay the restitution today. So it's something that we have to be able to do in person.
Do you have any idea of when we want to have that stuff for this afternoon?
I would indicate to the court, I think I'm back before the court for 2 hearings at 2:45 and 3. So I would suggest that if we set it in that time frame, that would give him the maximum amount of time to be here. And also, I think all the parties are going to be here anyway for the other hearings.
Okay. Right. Next matter is People versus Daniel Renoulet, case number 236505.
People.
Thank you, Your Honor. Richard Church, on behalf of Mr. Renoulet.
This is the date time set for sentencing in this matter. Sir, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Church about that?
Yes, sir, I have.
Mr. Church, are there any? I know we do have a prosecutor's challenge to one of the guidelines, but one of the variables rather. But we'll get to that in a second. Mr. Church, do you have any corrections that you can do?
No, Your Honor.
And do you have any challenges?
Or, I'm sorry, there is one correction. We have. There is an issue with the jail credit as calculated. And.
That's yours.
Sorry, two things to address, Your Honor, and I'm catching up quickly here. The court did receive my response to the prosecutor's guidelines challenge. Is that accurate?
Yes.
Okay. The second thing that I want to address, it's on CFJ 145, page 2. And that is, I think, the first page of the actual pre-sentence investigation report that contains the calculated jail credit. It indicates 2 days for the initial arrest in February of 2023. Mr. Renaway was also arrested in January of this year, where he was there from January 31st to February 7th, which would be an additional 8 days of credit that I think he's entitled to.
Judge, it's an unrelated charge, and I don't believe the credit applies. You can speak to probation and parole on that in your opinion as well.
It was a bench warrant for this case.
And the bond, there was,
in front of me in 2 days of jail credit, that would be something that I'd have to have the jail and ask for.
and there was an order revoking bond and remanding him to the jail February 1st. I don't know.
There was.
Yes, sir.
Yes, sir, you reinstated my bond.
If I have questions for you, sir, I'll ask you.
I'm sorry.
Okay? I don't need 5 people talking in my ear.
My apologies.
All right.
Yes, sir, on
February
February 1st.
1st.
Yes, sir.
All right, so I think he would be entitled to those days then if the court revoked his bond on those files. So 8 additional days, that gives us 10 days credit.
No additional corrections.
All right, thank you. And did you have any challenges to the scoring?
And no, just the response that we made to the prosecutors.
Mr. Rolla, does people have any additions, deletions, or corrections?
Other than as already indicated in our sentencing memorandum note.
Okay, and Mr. Rolla, again, I did have a chance to review your challenge, but if you could state it for the record.
Yes, Judge, this is a situation where PRV 5 was scored at 15 points in the PSR, indicating that there should have been scoring for 6 or less prior scorable misdemeanors. We would indicate the defendant, we believe, has 7 or more prior juvenile and or adult scorable misdemeanors. As the juvenile record, he has 2 prior scorable ones, 1991 adjudications for larceny and malicious destruction of property, as indicated under items 1 and 2 of Exhibit A. That's his record. And also the defendant has 5 additional scorable adult offenses: a 94 larceny, $100 or less, in 1998 drunk driving, a 2000 reckless, which is really the issue here, I believe, a 2002 operating under influence second offense, and a 2002 operating while impaired. As to the reckless driving, I would indicate specifically, Your Honor, under the statute that applies, it indicates that scoring is to be done under MCL 777.55A1, where the offense involves a matter which is endangering safety or persons. As the court's well aware, under the very definition of reckless driving, one of the elements that the prosecution has to prove is that a defendant operated a motor vehicle in a manner endangering persons or property. So we would indicate specifically in that regard, that for that alone, that in fact that would qualify. I would also indicate to the court, there's a case that's called People versus Robert Wayne Perry, Court of Appeals number 286065, that actually dealt with this issue. I have a copy. I'll be happy to provide it to the court. I know it. But it was where the reckless driving was in fact challenged by the defense. And the court indicated that it would have scored not because it wasn't qualifiable under PRV 5, but because in this case, a 10-year gap applied. There is no 10-year gap here. So in this case, Your Honor, we'd indicate both under case law and under statutory law, the reckless driving should count, in which case it would be 7 qualifiable offenses, so it would be 20 points, not 15 points. I hope I did that succinctly.
Thank you. And I agree. I mean, I think the issue here is that reckless driving offense. Thank you. Mr. Trush.
So, Your Honor, I'll keep it brief in regards to this. The issue is reckless driving. I cited case law in my response to the court, I think it was People versus Williams, which pretty, I think, spot on addresses that issue and says that reckless driving, even if there's evidence to support that alcohol was involved or something like that, it doesn't qualify and score that way. I'm familiar with the case that the prosecutor was citing to of Robert Wayne Perry. I have a copy of that in front of me as well. I would indicate, I disagree with what the prosecutor says the premise is. I don't think the court is saying that they would score it otherwise. I think what the court says here is, look, this is 10-year gapped out. I don't think they get to any other issues as to whether it's scoreable or not scoreable for any other reason. I think when they say it's 10-year gapped out, they don't address the merits of whether or not there would be a valid challenge otherwise to it. And I would caution the court, I think we also don't know what specifically is challenged with it. So, I mean, a challenge is limited to what the defense raises, meaning if the defense is only challenging it based on the 10-year gap, there'd be no reason for the Court of Appeals to go into the merits of whether or not there's another valid challenge to it, if that's in fact what it is. So that's my reading of Robert Wayne Perry. And I mean, the court obviously can read through that case. I would indicate, one, it's unpublished, whereas the case that I cited in the court is a published opinion and binding on the court. I don't think that the reckless driving should be scored, which would leave us at 6, which would leave the guidelines calculated exactly where the department has them.
All right, I did have a chance to review the submissions of the parties prior to the hearing today. I've had a chance, just as we've been talking here, to look at the Perry case that Mr. Rolla provided. I do believe it's correctly scored. I had a chance to look at the statute governing this variable, as well as the conviction. I had a chance to read the case that Mr. True cited, which my reading does support the department's scoring of this, not being that in. And then without having time to conduct a really thorough reading of Perry, it does look like the issue there is the 10-year gap, and I don't see where the court says that it otherwise would have been scoreable. So for those reasons, the court is going to deny the challenge, and the court will have the SIR remain as it's currently scored. Did you have any other challenges, Mr. Rolla?
No, Judge.
Okay. Mr. Rolla, anything on behalf of the people for allocation?
Judge, it's the 7 felony situation. The defendant, the recognition in this case is 2 days with 2 days credit for the 7th felony. Quite frankly, it's probably, in people's opinion, an insult to the criminal justice system. As this defendant was sentenced to MDOC on a last felony for drunk driving 3rd in August of 2009, and has a second controlled substance felony, that's number 11, delivery of marijuana. This is his 6th substance abuse offense. 2 days jail and 2 days credit, quite frankly, is not an appropriate sentence. And I think a very wrong message would be sent to the public would follow that recommendation.
All right, thank you, Mr. Church.
So, you know, I would disagree. I think that when the court looks at Mr. Renelay's specific circumstances, the recommendation here makes a lot of sense. So we'll start with the fact that, yes, the prior history as cited by the prosecutor is correct, but what's not accounted for in there is the vast majority of his prior criminal history is driving a suspended driver's license. He has no convictions post 2009, I believe, that aren't for driving a suspended driver's license, which means for over 10 years, he doesn't have any convictions for anything other than driving when he's not supposed to. And Mr. Renelay will be the first to tell you he shouldn't be doing that, and he's actively trying to get a driver's license back. But I don't think I have to tell the court how difficult of a process that can be, especially when Mr. Renelay has made that difficult on himself by continuing to drive when he's not supposed to. But since 2009, he doesn't have any convictions other than for driving a suspended driver's license. In addition to that, I think Mr. Renelay's personal circumstances warrant a response like this from the court. And as the court's aware, because this has been something that's come up pretty consistently throughout the case, his wife has a traumatic brain injury. She has significant needs that require him to be there to care for her. I will tell you, Mr. Runaway will be the first to tell you that he is remorseful that he's put himself in a position where he has to argue and fight to be able to be there for his wife right now. He'll tell you it's stupid that he did the things that he did. And again, he's put himself in a position where there's a real risk that he may not be able to be there for his wife when she needs it. Those things combined with the age of his prior history, I think warrant a response like what's recommended here by probation. I would suggest to the court, if the court isn't inclined to follow that, holding jail in abeyance may be appropriate with probation. But I would also indicate, I think he lives in the Traverse City area, which makes probation a little more of a challenging proposition. So given his personal circumstances, I think this recommendation does make sense. And I would ask the court to follow it.
Thank you. Mr. Riley, anything that you wanted to say?
I just wanted to apologize to the court for consuming the court's time like this, for the time we've been late with issues with my wife. This is a stupid decision. I'll have to live with this for a long time and regret this. It's caused problems at home with my wife that we didn't need on top of the stuff that we already deal with. She's had 2 brain tumor operations, 36 doses of radiation. We have to go to Ann Arbor this coming weekend for an MRI or 6-month checkup. I jeopardized a lot and I feel like a complete idiot. I need to be there for her because I've spent too much time not being there, being just due to this being stupid. And I'm just really regretful for it. And I appreciate the court's time, consideration, and everything, you know, for everything I've had to deal with and put up. You guys have put up with me being late and stuff not happening appropriately. I'm just very apologetic for that.
All right, thank you. I did review the report, so I'm familiar with the circumstances here. I'm familiar with your circumstances, both from the information in the report as well as what the lawyers had to say. And I guess there's a couple things I would say. Number one, you know, I don't particularly see the fact that you haven't had any other crimes other than driving while license suspended since 2009 as a mitigating factor. I mean, you're still committing crimes. I mean, you know, you're not supposed to be driving and you're still like, okay, well, I'm just going to drive. And if I get caught, I get caught. So to me, that's not like, oh, well, he hasn't had anything except like you've been continuing to break the law pretty consistently over a period of time. So I don't find that to be a mitigating circumstance. I'm absolutely sympathetic to your situation with your wife, and I'm sorry for what she's going through. That's difficult for anybody, including family members. But I'm not going to tailor my sentence around what's good for you or convenient for you. And the fact that you live in Traverse City is not a reason to not put you on probation, because that would make things more difficult. I mean, you're the one, as Mr. Trush has said, that put yourself in this position. And if your wife's health and everything is that important to you, then you wouldn't be doing what you were doing in this case. Aside from that, you're putting the public at risk in driving in the condition that you were in. So not only are you jeopardizing your ability to care for your wife and therefore jeopardizing her health, but you're also jeopardizing other people on the roadway who are out there with you driving. So yeah, a lot of bad decisions. I do think, though, given as a whole, that there needs to be some supervision. I'm not just going to cut you loose with 10 days in jail.
Sure.
So the court's going to place you on probation for a period of 12 months. I am going to impose some jail time, and I'm going to hold that in abeyance. If you comply with your probation, then you won't ever have to serve that jail time, and you can do the things that you need to do. Telling me that. If you don't comply with your probation, then that's going to be a clear signal to me that all of these things you're talking about aren't important enough for you to do the things that you need to do to stay in line. And then it's going to be completely on you, and you'll have to do jail time regardless of what the consequences are to your wife or anybody else who is affected by your decisions.
I understand.
So the court is going to place you on probation for a period of 12 months. The court's going to adopt as the conditions of that probation all standard terms and conditions that would typically be imposed in a possession case like this. So Ms. Davis be notified Mr. Brunikel of that. The court is going to impose 6 months in the Otsego County Jail with credit for 10 days served. The court's going to hold that time in abeyance because at the discretion of the court. court is gonna order a crime victims assessment in the amount of $130, court costs in the amount of $325, attorney fees in the amount of $350, and a state cost of $68. That all relates to the possession charge. The operating while suspended, a $50 state cost. You do have the ability to request an appeal of the sentence, and Mr. Church provided acknowledgement of our rights.
And I just want to be clear, the count 5 is allowing a suspended person to operate.
Sorry. Thank you. Count 5. Yes. Yes. And Ms. Davis, how do we want to arrange for contact between Mr. Green and Ellen?
He could just confirm his telephone number, seeing that his address and telephone number is not listed in the PSI, and then agent can Thank you.
Good luck to you going forward.
Thank you,
Mr.
sir.
Rendeley,
Appreciate
and
the
I
time.
hope that your wife is okay.
Thank you.
Copy of the document. Thank you so much.
People versus Alexandria Davis, case number 246671. It should reflect Ms. Davis is present here in the courtroom. The date that for sentencing, if I could have counsel put your
Amanda Berger appearing on behalf of the people.
Thank you, Your Honor. Richard Trish, on behalf of Ms. Davis.
the date time set for sentencing in this matter. Ms. Davis, have you had an opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sure.
Okay. And Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Roll, I did receive a number of victim impact statements. I had a chance, or I'm sorry, Mr. Rooker, I did have a chance to review all of those prior to the hearing today. Did you have any other additions, deletions? Yes,
No, Your Honor.
do you have any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the board here today in person?
Mr. Drex, I believe is here. I'm not sure whether he wants to address the board.
Your Honor, and my victim's impact would be sufficient.
Okay, Mr. Dresch, you said you don't want to come forward and make a statement.
No, not as-
Thank you,
Your Honor, I appreciate it.
Okay. All right, Ms. Bruker, then anything on behalf of the people for allegations?
Just briefly, Your Honor, I think what's interesting in this case is the things that have happened since this offense. Both her daughters do not want to see her at all. And since they've been removed from her care as a result of this offense, both of them are thriving in every way, educationally, emotionally, socially. They're doing much better than they were in Ms. Davis's care. Her younger child is the child who is the victim in this case. But as part of this crime, Ms. Davis also involved her older child by having her older child lie to the hospital personnel, by having her older child lie to their father about what had happened. Ms. Davis had her older child take accountability and had her tell her father that she's the one who harmed her sister, when in fact it was Ms. Davis who did that. At some point, both of the girls told what happened, and that was kind of what brought us here. Ms. Davis continued to lie about what had happened, but she brought her daughter for medical care when she first spoke to CPS and Gaylord City Police. Eventually, she did confess to them that she's the one who harmed her daughter, but it's a pattern with her. Not only was there this physical abuse, but there's also an emotional abuse component. name calling and of other ridiculing and just really shocking behavior that a mother would treat her children in that way that Ms. Davis has. Her daughters are terrified of her. Parenting time in the DHS case has not been suspended, but they don't want to see her. They don't want to attend visits with her, and they've not been attending visits with her since this happened. And her daughter could have lost her eye as a result of this. She did need medical care for it. I think she either had glue or stitches on it, but it came pretty close to being an injury that would have been much more serious than this. I know the guidelines are 0 to 11 months. I would ask the court to consider imposing some jail up front so that, well, as a punitive aspect, and to continue to protect these girls for an additional period of time, to show Ms. Davis that this behavior is not acceptable. I read the PSI. I'm empathetic to the fact that Ms. Davis has had some abuse and neglect in her childhood, but she can't pass that trauma onto her daughters. And that's exactly what she did and what she has done in the past, as indicated by this conviction. So I would ask the court to impose some jail up front on this case. And otherwise, beyond that, I don't have any objections to the other recommendations that are in the PSI.
Thank you, Mr. Church.
So, Your Honor, I would agree with a lot of what the prosecutor said there. And I think that Ms. Davis will be the first to tell you this is not an acceptable circumstance. There's certainly trauma in her history, and I'm certain that she does not want to perpetuate the cycle and pass this on. The situation that happened here is unacceptable. Ms. Davis knows that. She came here and she told Your Honor what happened. She's accepted responsibility for it. I agree with the prosecutor that what's happened since the incident is very important. It's unfortunate to hear, some of the trauma that the girls have gone through and that the kids are going through and that they don't want to see her. But I would say we have the visitation reports from the CPS case. We actually have a lot of information from the CPS case. Ms. Davis has been engaged with CPS. She's been working through her parent agency treatment plan with them. She's been attending the visitations, and it's accurate that the kids don't want to meet with her. And it's accurate that because of that, I don't think the visitations are really happening. But it is important to note that she's showing up, she's continuing to do the things that she's supposed to. And by the visitation reports, she's showing up prepared. And frankly, she is accepting that her daughters don't want to see her with a positive and appropriate attitude. In addition to that, as part of the CPS case, she's undergone a psychological evaluation, which we'd like to have attached to the PSI. And I can provide Your Honor with a copy if he wants to review it. But frankly, I think it provides a very good outline for the things that she can and should be doing to address these issues, things that I think would be appropriate for probation to be monitoring for her to continue to do. The CPS case is going to monitor that as well, obviously. But again, there's an additional element to it if Your Honor is monitoring it as well.
Mr. Krueger, do you have any objection?
I've not seen it. I know that a lot of, like, I represented DHS for years. I know that they involve a lot of self-reporting, so I've not seen it to know what's in it. I don't have an objection, I guess, to the recommendations probably, but.
Do you have an objection to the court attaching it to the PSI so that probation has a copy of that?
Let's take a look at it for a moment.
Okay.
And Your Honor, I have 2 copies. I do need one back for my client, but I can provide it to Your Honor to review at the same time.
Thank you.
I don't have an objection. I'd like to make a note.
Sure, just give me 1 second. Ms. Parker?
I just want to know, I'm not sure that Judge Cooper has jurisdiction in that case yet. She may be working in the services, but I'm not sure he's formally ordered to service the plan yet. I just wanted the court to be aware of that.
And did you have a copy that you wanted attached?
I did, and I've provided that to Ms.
Okay.
Davis already.
Great.
There were just a few more points that I wanted to make, and actually one of them dovetails from Ms. Brooker's point.
Okay.
So in addition to those things, I want the court to recognize, obviously, Ms. Davis has no prior criminal history. She has a juvenile adjudication from over 10 years ago for a retail fraud, but no adult criminal history, misdemeanor or felony. She's employed, and as Ms. Brooker indicated, factually accurate. The plea hearing is scheduled in the DHS case. It hasn't happened yet, which means correctly, Judge Cooper does not have jurisdiction over the case and the authority to order things. But I think if anything, that is in Ms. Davis's benefit because she's voluntarily engaged in all of those things at this point. There's not a court order requiring her to do them, but she's still engaged in doing them.
Thank you. Anything further?
I would indicate, I would ask if the court is going to impose any jail to hold it in abeyance, allow her to continue to work the program.
All right, thank you. Ms. Davis, is there anything you wanted to say?
I just want to say, Your Honor, I made a mistake. I didn't do good for me or my children. I was falling. I needed help and I was afraid to ask for help. So this is my opportunity to do better for myself and my children.
Thank you. I did read through the report. As I said, I also read through the statements that were given by Mr. Dross, of course, father, as well as both children. And I read through all the information in the report. I've just had a chance to look at this evaluation that was provided. And so looking at things all together, number one, I don't think this was a one-time incident with the butter knife. Based on what your children said in their reports, that it was abuse, both physical and psychological, was a common occurrence at your house. And I think, you know, this wasn't a one-time incident. I absolutely don't believe your statements in that report to DHS about, oh, I made a mistake and I was just trying to get rid of the knife and it flew and hit my daughter in the head. I mean, there's no version from anybody else of this that backs that up. And so the fact that you're continuing to like gloss over this and act like it was some kind of accident concerns me. I think it's ridiculous at this point that you're still trying to claim that you didn't mean to do this, when clearly, in my view, based on what your children have said in their statements, and I have no reason to doubt them, that kind of thing, maybe not throwing knives, but certainly physical abuse, name calling, those types of things was something that frequently occurred when they were in your custody. So I think there's a lot of work that you're going to need to do on yourself to come to terms with this. And I think you need some time to think about it. I think jail time is absolutely appropriate in this circumstance, given your behavior towards these children, both as a punishment to you and a consequence to you. So you understand that this is not appropriate in any way. And you need to start being real with yourself about how you're treating these children, not trying to claim it was some kind of accident or it didn't happen. And number two, the deterrent effect. I think the court needs to impose jail time for this type of crime because it's not acceptable in any way for an adult under any circumstances, no matter how frustrated, how stressed out you are, to treat children in this manner over a period of time continuously. I also think that probation is appropriate to make sure that you're following up with some of the things that you're required to do. And so that the court has some supervision over you during this process, along with other agencies, to make sure that these children are safe to the extent that you have contact with them, that it's monitored, and that they aren't subjected to this kind of abuse going forward. And I understand that you may have experienced some of this. I don't know to what degree, because I don't know how much to believe of what you put in that report in terms of what's happened to you, because I don't feel like you're being truthful. But it is a cyclical thing in domestic abuse, whether it's partner to partner or parent to child, tends to be repeated over generations. And I think it's really important so that these children going forward don't get caught up in that, to make sure that, again, the contact you have with them is healthy, that it's monitored, that it's supervised. So for all those reasons, I do think probation is also appropriate. So the court is going to follow the recommendation in that you will be placed on probation for a period of 2 years. Court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. Court is going to order that you serve 6 months in the Otsego County Jail with credit for 1 day served. The court is going to order that you serve that full 6 months. The court is not going to allow you to be released to work camp or any other early release. I think it's important that you serve that time as a punishment for your actions in this case. The court is going to adopt, if I haven't said it already, all the terms and conditions listed in the report as the terms of your probation. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a state cost of $68, along with a $30 per month supervision fee while you're on probation. You do have the ability to seek an appeal of the sentence, and Mr. Trush will provide Ms. Davis with an acknowledgement of the motion. Thank you. All right, sir, at the Crawford County Jail, can you tell me your name, please?
Raymond McLeod, Your Honor.
Thank you. We're on the record in People versus McLeod. This is case number 236613. The record should reflect Mr. McLeod is present today by video from Crawford County Jail. Thank you, counsel, put your appearances out, please.
Thank you, Your Honor. For the record, Michael, on behalf of the people.
Thank you, Your Honor. Richard Trush, attorney on behalf of Mr. McLeod.
Mr. Trush, how did we want to proceed in Mr. McLeod's case today?
Thank you, Your Honor. Mr. McLeod's situation is a little bit complex. So he has the matter here. He also has a matter that's holding in Crawford County, as well as I believe he has a matter up in Menominee County as well. I believe we do have a resolution of this for the court today. Mr. McLeod would be tendering a plea in this file to felon in possession of a firearm and felony firearm, both as habitual seconds. In exchange for that, the remainder of that complaint would be dismissed. I believe, and it might be Friday, can you correct me if I'm wrong, but he is set to tender a plea up in Menominee County. I don't know the specifics of that plea, but I think he does. And the Crawford County prosecutor has indicated, and again, not that this is part of the deal, but she is going to dismiss the charge there as long as he receives at least 36 months and the case here.
All right.
Which is a virtual certainty given the 2-year mandatory consecutive.
All right, so just to be clear, there's a number of different counts that would apply, but I'm looking at count 2, which is felony firearm, count 3, which is that firearms possession by a felon, so we'd be pleading to those 2 counts.
I think technically it would be 3 and 4, because I think count 2 applies. The predicate
count
felony.
1. Gotcha, okay. So counts 3 and 4 and all other charges and enhancements will be dismissed.
He is pleading as a have to.
Have to, okay. Roll.
Judge, unfortunately, the recitation of Mr. Truce is correct in the most part. However, it's not correct because in my communications with defense counsel on the 4th at 3:39 p.m., I indicated that as the offer that was made to Mr. McLeod was contingent, was originally based upon certain pleas that he was going to be entering in Crawford County and Menominee County. And then our office found out that that turned out not to be the case. We indicated to defense counsel that although we were not revoking the plea offer, we wanted to find out exactly what he was pleading to in Menominee County before we were going to allow him to go ahead with the plea offer in Otsego County, because as it turns out, Your Honor, the plea in Menominee County is allegedly the same plea that the defendant would have been entered in Crawford County, except we now find out that Crawford County is going to be dismissing their charges. So I can't know that that's going to take place until after it takes place. So I would respectfully request that this plea offer be moved to the court's next hearing so that we can actually know what in fact is taking place with Mr. McLeod, because the people will not take his word for what he claims is going to take place.
All right, Mr. Church.
And I would indicate, I did respond back to the prosecutor and suggest, I think there's an obvious workaround to that situation whereby Mr. McLeod, what is the plea offer in Menominee County?
Plead guilty to possession of cocaine. Dismiss
And
all
is
other. Yes, Your Honor.
Any enhancements to that?
No, Your Honor.
So my suggestion would be that we can make the plea contingent on him accepting that offer. And again, it's later this week. Is that correct?
Yes, sir. Yes, sir.
If he does not follow through on his end of it and take the plea in the other county, the prosecutor would have a basis to withdraw the offer.
Mr. Rowe.
Well, Judge, I guess that might be in the defense mind a workaround, but again, until it's occurred, I don't know how the people can accept that that is going to be the case. I don't know what's going to happen in Menominee County, and I don't want to have to revisit this issue again and say, oh, now you're locked into the offer, even though Mr. McLeod didn't follow through, and then we have to bring a motion to rescind the offer and go back to start all over again. I mean,
Your Honor.
No.
Okay, well, Mr. Rowe, I guess there's two choices for the people here today, and I'll hear from Mr. Church, of course, but I'm gonna leave the option up to you, because it doesn't matter to me whether we take the plea today or whether we wait. So I think option number one is we take a conditional plea today, the understanding that the prosecution can withdraw that plea at the time of sentencing, plea offer at the time of sentencing, if it doesn't go the way it's anticipated, or we can simply adjourn this hearing and set it for a plea hearing at a later date.
and again, as to the contingency plea, Judge, to this charge in Menominee County, I don't know what other additives there are to that. I don't know if there's an agreement for a deferral. I don't know if there's an agreement for some type of request for 7411 or some other such charge. That is the crux of the people's concern at this point in time.
Okay. So, Mr. Church, do you have any particular objection to the court setting this for a plea hearing after the plea of Menominee is taken?
I don't, Your Honor. I would indicate, I mean, this has kind of been the cat and mouse of this all along, is Crawford, everybody keeps, who's going to bow first, who's going to curtsy, right?
Right.
I don't have an objection to adjourning it. I mean, again, we expect to effectuate it very soon.
So I'm going to set this for a plea hearing at the court's next date, and let's see where we're at that point. Because frankly, I mean, I get what you're saying about the cat and mouse thing. Unfortunately, if we take a conditional plea today, that doesn't do anything anyway, because we'd be withdrawn. So let's just, we got the plea hearing in the nominee next week. We'll go forward with that. The court will set this for another date. Go from there.
Understood.
Okay. All right, Mr. McLeod, do you have any questions at all?
Your Honor, Friday is my plea acceptance, in Menominee County, 2 days from now. I was supposed to accept the plea 2 weeks ago, but there was issues with their Zoom, so they had to postpone it until this Friday.
Okay. All right, sounds good. Well, we'll proceed further in your case here once that plea happens later this week, okay?
Okay.
All right, thank you. The court can disconnect at this time. Mr. Flagstad, were you ready on Mr. Martin's case? Okay. People versus Martin, case number 236620. I get counsel put the appearances on.
Thank you, for the record, my comment to people.
Judge Mike Clay on behalf of Mr. Martin.
Mr. Flagstad, how do we want to proceed?
Judge, I am pleased to report that the Sheboygan County Treatment Board has accepted Mr. Martin. With that understanding, Judge, today we'd like to enter a plea as charged. Provided that meets the court's satisfaction. I do have an advice of rights as well as a memorandum of understanding on that approach.
Yes, please. And so, Mr. Martin, can you please? Every charge.
Yes, Your Honor.
Mr. Rowland?
That's correct, Judge.
Okay. And the agreement is that as part of sentencing, he'll participate in the sobriety court.
That is correct, Your Honor.
Yes, Judge, and the court should have the signed documents before it's signed, executed both by myself, Mr. Flagstad, and his client. We will require, however, your Honor's signature or indicating your agreement and having this done.
And Judge, you're so lucky. I think you get to sign twice, actually, provided, again, meets your satisfaction.
Okay, Mr. Martin, have you had an opportunity to actually, it's gonna have to go to Judge Hunter, he's the chief judge, so.
Okay, Your Honor. That was not my understanding,
But
but
I'll sign my spot under the assigned judge, the transferring court. Mr. Martin, have you had a chance to discuss this with Mr. Flagstad?
Yes, I have.
And is that how you want to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Mr. Martin, are you currently on any kind of probation or parole?
No, I'm not.
All right, and you understand that by pleading guilty to count 1, which is operating while intoxicated as a third offense, that the maximum possible penalty you could face would be up to 5 years in prison and or a $5,000 fine.
Yes, I do.
I'm sorry. This is as a habitual third, so
It'd be 10 years.
we're actually looking at up to 10 years. You understand that?
Yes.
Okay. Then count 2, operating with a suspended license, that is a 93-day misdemeanor. Do you understand that?
Yes.
Count 3, which is operating without insurance, again, a misdemeanor, punishable by not more than 1 year and at least a $200 fine. Do you understand that?
Yes.
And then finally, count 4, which is operating vehicle with an improper plate, that is a misdemeanor, punishable up to 90 days and or a $100 fine. Do you understand that?
Yes.
With all of those penalties in mind, what is your plea to each of those charges today?
Guilty.
Okay, I know you signed the advice of rights form, but I'm going to go through those rights with you here on the record as well. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, I do, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the Court of Appeals, which is the next higher court up, to hear your case. They could say no, and then that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are guilty of each of these charges?
yes,
So this happened on August 26th of 2023. Is that the correct date?
yes,
On that date, had you been consuming alcohol?
yes,
And after you consumed alcohol, did you operate a vehicle on M32 Main Street here in Gaylord by the Taco Bell parking lot?
yes, Your Honor.
Okay. And at the time that you were operating that vehicle, had you consumed enough alcohol that you were unable to operate that vehicle in a normal and safe manner?
Yes,
Did you have any blood or breath tests done to determine the level of alcohol in your system?
yes, I have.
Do you remember what that result was?
I believe the breathalyzer was a 0.141. I believe there's a blood alcohol test on it was a 0.16.
Do you have any reason to doubt the accuracy of either of those tests?
No,
All right. Had you previously been convicted of operating while intoxicated back in August of 2019 in Emmett County?
yes,
Had you previously been convicted of operating while intoxicated back in 2017 in Charlevoix County?
yes,
Had you previously, okay, and the one in 2019, that was the third offense, is that correct?
yes,
And had you previously been convicted of resisting or obstructing a police officer in the Third Circuit Court in Charlevoix County back in 2019 as well?
yes,
At the time that you were operating this vehicle back on August 26th of 2023, did you have a valid driver's license?
no,
And did the vehicle that you were operating, which is a 1990 Chevrolet pickup, did it have proper insurance securing that vehicle?
did not,
And did that vehicle have a proper plate that was registered to that particular vehicle?
no. I believe that plate, though, that plate never, it was the original plate that was on that truck when I bought it. But it's definitely it hasn't been renewed and wasn't off of anything else.
Okay, didn't come from a different vehicle, but it wasn't up to date in the registration.
That's correct.
Okay, thank you. All right, Mr. Rolla, are the people satisfied with the factual basis as to all charges?
With one circumstance, and I may have missed it, Judge, as to the parking lot of Taco Bell, which making a finding that this is an area that was open to the public for the parking or operating motor vehicles.
Yes.
Then with that, Judge, Your Honor, the people are satisfied the court has sufficient factual basis to accept defendant's guilty pleas as to counts 1, 2, 3, and 4. We're aware of no threats, promises, or other inducements not placed on the record. Thank you.
Mr. Flagstaff.
Judge, I think it is also a sufficient factual basis, and I would agree that I'm not aware of any threats, promises, or proper inducements.
All right, Mr. Roller, are the people satisfied that the court is otherwise complied with statute, court rule, and taking of this plea?
We are, Judge. Thank
Mr. Flagstaff.
Yes, Your Honor.
Mr. Martin, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. You can meet with Ms. Davis before you leave today to set up a pre-sentence interview. And the court will set this for a sentencing hearing. Just make sure that you stay in touch with your attorney prior to that hearing. Mr. Clagstead, I'm going to give you back the order transferring so that you can get that to Judge Hunter's office for signature from the chief judge. Thank you. Otherwise, I'll put the other documents in the file. And that's all for today. Thank you.
Thank you, Your Honor.
Thank you, Judge.
Deputy, can you let Mr. Trush know that we're ready for his next hearing, please? We have Mr. Ball present, Eric Ball.
Mr. Ball is here. He stepped out to talk with his significant other about whether or not we're going to engage in the offer that's been made or not. I do have Mr. Brewer present, ready to proceed.
Mr. Woodcoker, we're gonna call your case in just a minute, so I'm just gonna keep you here in the courtroom for right now, okay? People versus Robert Brewer, case number 246681. Brewer present.
Michael, on behalf of people.
Here's how to proceed in this case today.
Thank you, Your Honor. In regards to this case, we are in receipt of an offer that we intend to take advantage of today. That offer would be, Mr. Brewer would tender a plea for count 1, count 2 would be dismissed. We intend to take advantage of that today. I would suggest to the court, we're going to ask for a little longer time period in terms of sentencing. Mr. Brewer is set for a substance abuse assessment, I think, on Monday. We want to make sure that that gets completed before sentencing.
Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge, and for the record, people have no objection to having Mr. Brewer get any and all assessments in regards to his substance abuse. We'd rather have that addressed by this court and another court in the future.
All right, Mr. Brewer, is that how you want to proceed today?
Yes, Your Honor.
Raise your right hand, please. We solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Brewer, are you currently on any kind of probation or parole?
I'm bond.
You're on bond. Okay. You understand that the maximum possible penalty you can face for count 1, which is delivery of amphetamines, is up to 7 years and or a $10,000 fine.
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during the trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights, including the right to have a trial.
Yes, Your Honor.
Also, you don't have any automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the next higher court up, Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today? Is it your own free choice to enter this plea? Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay. This happened back on June 27th of 2022. Is that the correct date?
Yes, Your Honor.
Okay. Back at that time, were you here in Otsego County?
Yes, Your Honor.
And while you were here in Otsego County at that time, did you have some amphetamines?
Yes, Your Honor.
And did you give or sell that substance to another person?
Yes, Your Honor.
Did you have any legal right to do that at that time?
No, Your Honor.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Truth?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge, thank you.
Mr. Church?
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute, court rule, and the taking of its plea?
Yes, Your Honor.
Mr. Truth?
I am satisfied.
Mr. Brewer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Ms. Davis before you leave here today to set up a pre-sentence interview. The court's going to set this for a sentencing hearing in about 60 days. It's important for you to make sure you stay in touch with Mr. Trush so that you're ready to go on that day, okay?
Yes, Your Honor.
Judge, one other thing for the record, and Mr. Truce, I believe will confirm this plea agreement does include the restitution the same in the amount of $200.
And we have no objection to that.
Thank you. Mr. Boer, just make sure you touch base with Ms. Davis here before you leave.
All right, thank you.
All right, do we have Mr. Ball?
Go and retrieve him. I appreciate the time. I know he's contemplated right now. We received an offer from the Attorney General. And again, he's contemplating if he's gonna take that or not.
You want to take Ms. Cruz's case while we're waiting?
They're just checking him through and I think we'll be ready to go. And we do intend to accept the plea.
All right, we'll go on the record in People versus Eric Ball. This is case number 2365597. And we have Mr. Wuda Coker on behalf of the people appearing by Zoom today from the AG's office. Mr. Ball is present here in the courtroom with his counsel, Mr. Trush. And so, Mr. Trush, can you tell me what the terms of the plea agreement would be?
Thank you, Your Honor. So my understanding of the agreement is that Mr. Ball will be tendering a plea to count 1. The enhancements would be dismissed and they don't have an objection to it being done under a late, under a year delayed sentence. With Mr. Ball paying his obligation during that year. And then again, the Attorney General can elaborate, but I think if he reduces it by half, they would reduce it to an attempt. If he reduces it all the way, they would reduce it to a misdemeanor. I think that accurately puts out the agreement.
Mr. Wuda Coker?
Yes, Your Honor. Just for clarification, Mr. Ball can plead guilty to count 1 and the information. The people will dismiss the habitual offense notice. The people will further recommend an 11-month delayed sentence. During that delay, Mr. Ball is required to pay his child support as ordered. If he's able to reduce his arrearage down to $29,000 or less, the charge will be reduced to an attempt felony non-support. And if he's able to reduce his arrearage to 0, the charge will be reduced to a misdemeanor disorderly person.
Thank you. Okay, Mr. Trush, is that your understanding as well?
That is accurate, Your Honor. And we would be seeking to do a no contest plea. I have a police report for Your Honor. And to elaborate, I mean, the issue in this case has been whether or not the order from the court, this under the court order is accurate in terms of we think that he's been assessed too much child support based on the circumstances. So the no contest plea would be he still intends to try to correct the arrearage amount that he has. So we don't want to make an admission that would suggest that that is an accurate amount, although it would acknowledge that he has not paid.
All right, Mr. Wood-Coker, do you have any objection to the no contest plea?
I guess no objection. I guess I don't see the purpose of it, but no objection, Your Honor.
Okay, thank you.
And I would indicate this is the report from the Attorney General's investigator.
I think it's a reasonable basis to accept the no contest plea. So as long as there's no objection from the people, I don't have an objection to accepting it as a no contest. So, Mr. Ball, have you had a chance to talk to Mr. Trish about this?
Yes, Your Honor.
Okay. And is this how you want to proceed here today?
It is, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Ball, you understand, well, first of all, are you on any kind of probation or parole at this time?
No, sir.
All right. You understand that the maximum possible penalty you could face for this charge, which is failing to pay child support, is up to 4 years and or a $2,000 fine.
Yes, Your Honor.
And with that maximum possible penalty in mind, what is your plea to that charge today?
No contest.
All right, right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading no contest?
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead no contest?
No, sir.
Has anybody promised you anything other than what we said here on the record today?
No, sir.
And is it your own free choice to enter this plea?
It is.
Okay. All right, I've reviewed the State of Michigan Department of Attorney General Police report here, and it is file number 22349-696. And that report reflects that that it's the finding of the Attorney General investigator that the defendant had not paid his child support as ordered by the Otsego County Court. So I find that there's an adequate factual basis based on the information contained within this report. Mr. Owuda-Coker, do you have any objection to the court using that report as the factual basis?
I do not, Your Honor. I guess my only concern, I guess there's nothing in the report that references the time period. At least that I can see. I guess if I'm sorry, go ahead.
We'll stipulate to the time period. I think it's between 17 and 21.
Yeah, between May 2017 and September 30th, 2021.
Okay, so the defense is stipulating that during that period of time, is the time frame for the failure to comply.
Correct.
Okay,
All right, people are satisfied then, Your Honor.
all right, thank you. Mr. Truce, are you satisfied?
Yes, Your Honor.
Okay, so the court's gonna mark and admit that as court exhibit 1. Mr. Awuda-Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record today?
No, Your Honor.
Mr. Truce?
No, Your Honor.
And Mr. Awuda-Coker, are the people satisfied that the courts complied with statute and court rule in the taking of this no contest plea?
Yes, the court has.
Defense is satisfied.
Mr. Ball, the court finds that your plea is knowing and voluntary. The court is satisfied based on court exhibit 1. There's a factual basis to support a finding that you are guilty of this charge. The court will accept your no contest plea. We'll set this matter for a sentencing date. Before you leave the courtroom, you're going to meet with Ms. Davis to set up a pre-sentence report. Okay. Otherwise, just make sure that you stay in touch with Mr. Trush. Mr. Awuda-Coker, if the people want to appear by Zoom for that sentencing hearing, please just notify my office ahead of time, okay?
All right, will do. Thank you.
And then the court will adjourn the trial date, which currently is set for March 28th in light of the plea today. Mr. Awuda-Coker, anything further that we need to address from your side?
No, Your Honor.
Mr. Trush?
No, Your Honor. Thank you.
Thank you, Mr. Ball. That's all for today. People versus Rebecca Ann Cruz, case number 236663.
Gentlemen, call that, please.
Thank you, Your Honor. Richard Trush on behalf of Ms. Cruz.
Thank you. Set for a conference in this case today, Mr. Trush.
Thank you, Your Honor. We are in receipt of an offer from the prosecutor's office whereby Ms. Cruz would admit to count 2, resisting instructing a police officer, and count 4, operating while intoxicated as a second offense, that being a 1-year misdemeanor. Count 1 and 3 would be dismissed. There is $200 of restitution sought to the state police for the blood draw.
Okay, thank you. Mr. Gola, is that a correct statement?
It is with the exception of the actual restitution is $425.65. According to our victims' rights advocate, that information has been provided to the defense counsel.
We don't dispute that. I would just indicate, I suspect that the additional amount there may come from damage to the police car.
Okay.
But that hadn't been quantified yet.
All right. Ms. Cruz, have you had a chance to talk to Mr. Trush about this plea agreement?
Yes, sir.
Okay. And is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Deputy, can you call the jail and just have them get Mr. Lundy on Polycom while we're doing this hearing? Thanks. All right, Ms. Cruz, are you currently on any kind of probation or?
I am on probation.
Okay, and where's that out of?
Crawford.
Okay, and are they aware of the plea that you're making here today?
Yes, sir.
Okay, and have they told you whether you're going to receive any kind of sanction with regard to your probation because of this plea?
I did speak with Officer Vanderbilt, Jessica, excuse me, Wolfen, sorry. And she says that she's satisfied with my probation time with her. I'm not sure if that's what I'm supposed to answer.
Okay, Mr. Trush, are you aware of any potential sanctions?
Ms. Cruz, is your probation agent in Crawford County, Ms. Norgon?
I've only spoken to Jessica Van Wolfen.
Well, Ms. Van Wolfen does community corrections here for Otsego County. Are you reporting to anybody in Crawford County right now?
No, sir.
Do you have a pending case there?
No, sir, I paid my fine already.
Okay, maybe we're just misunderstanding.
I mean, based on the information she's provided, I don't have anything to suggest when the Crawford prior may have been. But I would indicate a typical. If she were charged with a first offense drunk driving in Crawford County, being a low severity misdemeanor or a non-serious misdemeanor, a fines and cost sentence would be probable. So I don't believe that there is violation or consecutive sentencing exposure there.
Okay, all right, thank you. So Ms. Cruz, you understand that by pleading guilty to count 2, which is assaulting or resisting or obstructing a police officer, that maximum possible penalty is 2 years and or a $2,000 fine.
Yes, sir.
And that operating while intoxicated as a second offense, the maximum penalty you could face would be up to 93 days in jail, $500 fine, and or 60 days of community service. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Yes, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter into this plea?
Yes, sir.
Are you pleading guilty because you are guilty of each of these charges?
Yes, sir. I am legally responsible for driving my vehicle.
So this happened back on November 18th of 2023, is that the correct day?
Yes, sir.
And on that day, had you been consuming alcohol?
Yes, sir.
And after you consumed alcohol, did you operate a vehicle on Old 27 here in Otsego County?
I am legally responsible for driving my vehicle.
Okay, so you did drive your vehicle after you consumed alcohol?
Yes, sir.
Okay. Did you have any blood or breath tests done to determine the level of alcohol in your system at that time?
Yes, sir.
Do you remember what those results were?
0.20.
Okay. Do you have any reason to doubt the accuracy of that test?
No, sir.
Had you consumed enough alcohol that day that you would have a blood alcohol limit above the legal limit?
Yes, sir.
Did you encounter a sergeant or an officer from the Michigan State Police as part of that incident?
Yes, sir.
And was that individual wearing their uniform?
Yes, sir.
Did you know that that individual was there performing their duties as a police officer?
Yes, sir.
Mr. Trush, do you know what occurred here? Can you ask some questions about specifically what happened?
Yes. So Ms. Cruz, when you encountered that officer, did he give you some commands?
Yes, he did.
And did you comply with those?
I did, but I didn't do it fast enough. I was very scared.
Okay, so he told you to do something and you didn't immediately do it,
Yes, sir.
but you ultimately eventually did comply with that.
Yes, sir.
All right, thank you. Mr. Rolla, are you satisfied with the factual basis?
Court is sufficient factual basis to accept defendant's guilty pleas to counts 2 and 4, Your Honor.
Thank you. Mr. Trush.
There's a sufficient factual basis.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Trush.
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
People are satisfied, thank you.
Mr. Trush.
defense is satisfied.
Thank you. Ms. Cruz, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of these two charges. The court will accept your guilty plea as the full. You're going to meet with Ms. Davis before you leave court here today, set up a pre-sentence interview, and just make sure that you stay in touch with Mr. Trush prior to the sentencing hearing, okay?
Thank you, Your Honor.
Thank you.
I apologize. Thank you.
All right, sir, is your name Tristan Lundy?
Yes, sir.
We're on the record in People versus Tristan Lundy, case number 236668 and 246697. The record should reflect Mr. Lundy's present today by video from Otsego County Jail. If I could have counsel put your appearances in.
Thank you, for the record, I call the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Lundy.
Mr. Trush, tell me how you want to proceed on each of these files today.
So, Your Honor, I appreciate the court setting the newer file on sort of short notice. We asked the court to do that, and we're appreciative of that. The first thing I'd like to do is ask the court if we can address bond in the older file, that being 236668.
Okay, what's the bond currently?
I believe the court canceled his bond on the basis of the new, or revoked the bond on the basis of the new charges.
Okay. What are you asking for on that file today then?
So, Your Honor, I'd ask the court to consider reinstating the bond. The new charges that he picked up are an unfortunate incident, but there's a few things that I will point out to the court that I think are important considerations in regards to this. With the exception of this incident, he's been in compliance with his bond conditions. He has family support. He has family here in the courtroom. He has a stable place to live. In regards to the new charges, I do want to make it clear to the court that the person involved in that with him was of age to consent. The only issue that makes this a problem for the court really is the location in which it happened. So for those reasons, I've asked the court to consider reinstating the bond. I've been in discussions with the prosecutor. I ultimately do think we have an agreement that we're likely to enter into, but Mr. Lundy does have some concerns about being able to keep his living situation. And we know that if he enters into that plea, the court's necessarily going to have to cancel his bond. So our hope would be that we can get his bond reinstated. He can address the living situation. And in the beginning of April, we will be able to effectuate that plea, which would involve him admitting, I believe, 2 counts of CSC 4th-degree and an indecent exposure. And obviously those would necessitate the court revoking his bond at that time.
Mr. Nolan.
Judge, to not overstate the obvious, that's the new file. The court's aware of the current file, so the court on 2 counts of homosexual conduct in the 4th-degree with the victim between 13 and 15. It's alleged in the new file that the defendant, while out on bond, decided to engage in having sexual intercourse in a public parking lot with another individual, which led to the charges of gross indecency and indecent exposure. Now, I don't know if the court is mandated to have his bond revoked if he enters guilty pleas to the counts of criminal sexual conduct in the 4th-degree, although they do involve a minor, and that may be the rub on that. But quite frankly, the difficulty that people have is, well, here, let him out on bond before he enters guilty pleas because he's having concern about having a place to be, and then maybe we'll enter a guilty plea in the future. If he wants to enter a guilty plea, people have no objection to the defendant's bond being then addressed by the court. I just don't know if it's appropriate to do it at this stage.
And Your Honor, I mean, that is the rub of it. If he admits a CSC offense involving a underage person, I think the court has to, by statute, revoke his bond. And if the court disagrees with me, correct me, I think you have to. We would be amenable to the court placing him on a tether if the court required some additional assurances. Frankly, Your Honor, what I would indicate to the court, Mr. Lundy's been very forthright with what happened. He was honest with the police. I mean, he told them exactly what happened. This is not a case that's going to trial.
All right, well, I mean, here's the thing that I have a problem with. If he's gonna enter a plea to charges which require the court to revoke his bond, it doesn't make sense for me to grant him a bond, just for convenience sake. So at this point, the court's going to deny the request for bond. If there is no plea and if Mr. Lundy decides to proceed to trial, then I think the court would require to set a bond in some amount. But it would likely be, a substantial enough amount to ensure further compliance with conditions of bonds. It seems how he's already violated bond once. So I guess we'll see what happens at the next court hearing. We'll set that for hearing in April.
Well, yeah, I mean, I don't know that so I discussed with Mr. Lundy the whole sort of decision tree, so to speak. We wanted to address bond first because we know that if we do tender the plea, the court has to revoke his bond.
Right.
I discussed with him that we would raise bond first for that very issue. I believe he does intend to accept that plea today, assuming that the prosecutor is making that offer.
And again, we have not rescinded the offer, Judge. People made an offer in discussion with defense counsel last week, and it's in anticipation of perhaps all of these cases being resolved.
Okay. So what are the terms of that agreement then?
So in the older file, he would be acknowledging counts 1 and 2, both of which being CSC 4th degree. In the new file, he would be acknowledging the misdemeanor indecent exposure. Count 1, the gross indecency, would be dismissed. So that would be a misdemeanor plea, no felony involved.
That's correct, Judge.
All right.
Plea to both counts in file number 36668 FH and count 2 in file number 246697 FH. Count 1 in the latter file to be dismissed at the time of sentencing.
All right, Mr. Lundy, have you been able to hear all of that?
Not as clearly as I'd want to, but it is what it is, I guess.
Okay, do you want to have, move forward with the plea agreement today? Do you want to have some more time to discuss it with your attorney? How do you want to proceed?
I guess I could do the plea agreement. As I can hear, I'm not going to be able to get out on bond anyway, so.
Okay, were you able to hear the terms of that plea agreement that the lawyer stated?
Agree to the 2 counts of CSC 4th degree and the 1 count of indecency exposure.
That's correct. Is that the plea agreement that you've discussed with your attorney, Mr. Trush?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Lundy, are you on any probation or parole in any other cases?
No, sir.
Okay, and you understand that by pleading guilty to criminal sexual conduct 4th degree, that the maximum possible penalty that you could face would be up to 2 years and or a $500 fine on each charge?
I do.
And that by pleading guilty to indecent exposure, that's a misdemeanor, the maximum possible penalty is up to 1 year and or a $1,000 fine. Do you understand that?
Yes, sir.
With all of those maximum possible penalties in mind, what is your plea to each of those 3 charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all of those rights?
I do, sir.
And you understand that you're going to be giving up and waiving all of those rights, including the right to have a trial, by pleading guilty.
I do, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
I do, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to each of these charges because you are guilty?
Yes, sir.
Thank you, Mr. Trush. I'm going to ask that you conduct some questioning of your client to establish the factual basis.
Yes, sure. Mr. Lundy, can you hear me okay?
Yes, sir.
So on or about September 19th of 2023, were you here in Otsego County?
Yes, sir.
And on that date, did you have contact with Riley Gensler?
Yes, sir.
And on that date, was that contact sexual?
Yes, sir.
And did that involve a touching?
Yes, sir.
What area on her body did you touch?
Her chest and her butt, sir.
And at that time, are you aware of what Riley's age was?
No, sir.
Are you now aware that her age was less than 16 years of age?
I am, sir.
All right, Mr. Rolla. Oh, we need to, yeah, okay.
Moving over to the other file.
Well, we need to establish two. We need to
This
establish.
was done for a purpose of sexual gratification or reasonably construed to be for sexual gratification.
I mean, he said it was sexual contact.
Right. I'm satisfied with the sexual contact part, but we need to establish two incidents because we have two counts.
He said that he touched her breasts and her butt.
Okay.
Correct, Judge. People satisfied there's two separate incidents. The only other question is that she was over 13, but under 16. Again, just for the record, so that it's clear.
We've established that she's under the age of 16, so I think that's sufficient.
Very good, Judge. Thank you.
All right, Mr. Trush.
Okay, Mr. Lundy, now taking you to February of this year in 2024. On that date, did you have contact with Hannah Divish?
Yes, sir.
And on that date, were you in a parking lot?
Yes, sir.
And while you were in that parking lot, in a vehicle, were you in a stage of undress?
Yes, sir.
And were there other people that may have observed that?
Yes, sir.
Where was the parking lot at, Mr. Lundy?
The disc golf parking lot behind the middle school.
Well, we got one coming in. Yeah.
He said the disc golf parking lot behind the middle school.
Okay. And that's the middle school here in Gaylord?
Yes, sir.
All right, Mr. Rolla.
People are satisfied for a sufficient factual basis to accept the case 2466697 page as well.
Thank you, Mr. Church. Are you satisfied with the factual basis as to each of the three charges?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Church, there you go.
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
As to both files, yes, Judge, thank you.
Mr. Church.
Yes, Your Honor.
Mr. Lundy, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support finding that you are guilty of each of these charges. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. You'll be contacted by the probation department for a pre-sentence report, and then Mr. Truce, your attorney, will be in touch with you to go through that with you prior to the sentencing hearing, which will be in about 30 days. Mr. Roll, anything further we need to address for the record on this?
Not a bad, thank you.
Mr. Truce.
Two things very briefly. One, I would request that I be present at the PSI interview.
Okay, Ms. Davis, whoever's gonna do that, can you make sure Mr. Truce is made aware of the date and time of that?
Yes, sir.
And then secondly, Mr. Lundy had asked me to address a separate bond condition to the court. And Mr. Lundy, I reviewed your bond conditions yesterday. The other condition you wanted to address, there's nothing that prohibits that.
Yes,
So we don't need to address it to the court.
Okay. All right, thank you. That's all for today. Mr. Lundy, the court. People versus Barnett.
He's lodged at MDOC and the email says he's in quarantine. So he's not.
Okay, got it.
Yeah.
Okay, so recall People versus Barnett. This is case number 236659. Both counsel are present. This was set for a status conference today by Zoom from Department of Corrections, where defendants lodged. The court's in receipt of some information indicating that Mr. Barnett's currently in quarantine and can't be made available for the hearing today. So the court would just reset this, Mr. Truce, in the record that you want to make on that.
Your Honor, I would just briefly indicate, Mr. Barnett also has a matter in, I think, Sheboygan County. I've been in touch with his attorney there, and that's consistent with what happened with his hearing, I think, at the end of last week there.
Mr. Rolla, if the people can just prepare a new writ for by video once we get a date for that.
Very good, Robert. And again, people also agree that there's good cause to.
Thank you. People versus Corey Pickett, case number 246683, 6684, and 226401.
John, Mike, all of the people.
Thank you, Your Honor. Richard Truce on behalf of Mr. Pickett.
Okay, Mr. Pickett's present here in the courtroom today. Mr. Truce, how do we want to proceed on that?
Unfortunately, Your Honor, I haven't been able to get a hold of Mr. Pickett prior to today's date. The number that I've had for him, I think obviously was disconnected or not a good number anymore. I don't know if the court would like to take, I think the court has one more matter on the morning docket. If it wanted to take that and give me an opportunity to speak to Mr. Pickett, I'd be happy to do that. Or if the court just wanted to reschedule it and I can get a good number from Mr. Pickett.
A little bit of time here this morning, that my other hearing got canceled, so this is the last one in the morning. So Mr. Truce, I kind of would put the ball in your court, whether you want to do that or whether you'd like to have some time where you can actually sit down with Mr. Pickett more than 10 minutes that we'll have left here before lunch.
What I would suggest to the court is I'd like to talk to Mr. Pickett. Again, I don't know that we're necessarily going to get anything done, but at least it will allow me to get an idea of where we may be headed.
Okay, so we'll take a 10-minute break. We'll come back at 5 minutes too, and then we'll go from there. Okay, we're back on the record in People versus Pickett. Mr. Trish.
Thank you, Your Honor. I had an opportunity to talk to Mr. Pickett, and I actually believe that we're going to take care of all three of these today.
Okay. How did we want to first?
So in this might be harder for me to put out there than I thought. In 246683, is that the charge involving methamphetamine?
No, that's the felon in possession of firearm.
Okay, so he'll be.
You have possession of methamphetamine is the 6401.
So in the 6401, he would be pleading to the possession of methamphetamine and the driving under suspended.
6401 is his PV. The other possession of methamphetamine is 6684. And the felon in possession of firearm is 6683.
All right, so let's try this again. In 6684, he's pleading to the possession of methamphetamine. Both enhancements are dismissed, and he's pleading to the driving a suspended license as a second.
Right.
In 6683, he's pleading to the felon in possession of a firearm. The gun is forfeited, and the habitual offender notice is dismissed. In the probation violation file, he would be acknowledging the two technical violations. And I apologize, unfortunately, when I get the notices with the circuit court number, it doesn't tell me which file to attach it to.
Okay, no problem. All right, Mr. Pickett, you just kind of discussed this with Mr. Trush here this morning over the last 10 minutes. Are you ready to proceed? Do you feel comfortable going forward?
Yes.
Okay, do you want more time to talk to Mr. Trush about it, or do you want to get this taken care of today?
I'd like to get taken care of mostly today.
All right, okay. Okay, so please raise your right hand. Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So I hope you got.
Yes.
Thank you. Mr. Pickett, so aside from the probation case we have here today, are you on probation in any other cases?
No, sir.
Okay. And you understand that by pleading guilty in the newer files that's going to be a violation of your probation?
Yes.
Okay. And then you could face some penalties for violating your probation, which are over and above what will happen in the other files?
Yes.
Okay. And then you understand that by pleading guilty to possession of a firearm as a felon, that the maximum possible penalty is up to 5 years and or a $5,000 fine and mandatory forfeiture of that weapon. You understand that?
Yes.
And then you understand that by pleading guilty to possession of methamphetamine, that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine.
Yes.
And then finally, operating with a suspended license is a misdemeanor as a second offense that carries with it a maximum penalty of up to 1 year and or a $1,000 fine.
Yes.
Okay. With all of those things in mind, what is your plea to the charges of possession of a firearm by a felon, possession of methamphetamine, and driving on a suspended license?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Okay. So looking at the older charge, which goes back to June 29th of 2023. Back in June of 2023, were you here in Otsego County?
Yes.
And on or about June 29th, while you were here in Otsego County, did you get pulled over as part of a traffic stop on Otsego Lake Drive?
Yes.
And were you operating the vehicle at that time?
Yes.
And was your license suspended or revoked at the time you were operating that vehicle?
Yes.
Had you previously been convicted of operating with a suspended license back in 2017 in Bel Air?
Yes.
Okay.
I also got one like 2 weeks before this one.
Okay. And at that same time, when you were pulled over there on Otsego Lake Drive, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Okay, and then moving forward to November of 2023, so a couple months later, November 15th of 2023, were you here in Otsego County at that time?
Yes.
And while you were here in Otsego County, were you in possession of a firearm?
Yes.
And were you prohibited from possessing any firearms because you had previously been convicted of a felony?
Yes.
All right, Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge, unless you wanted to indicate what the prior felony was on the record.
I don't think it matters.
Very good, Judge.
Okay, Mr. Trush
I'm satisfied with the factual basis.
and Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
Mr. Trush,
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Trush.
Defense is satisfied.
Okay, thank you. As to those charges, Mr. Pickett, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of those charges. The court will accept your guilty plea. A couple more questions with regard to your probation. So you understand that you're charged with two probation violations arising out of the charges that we just discussed?
Yes.
Okay. And you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Yes.
And that you'd be giving up that right by pleading guilty today?
Yes.
And that it could subject you to the maximum possible penalty on your charge in that case, which is also possession of methamphetamine, which is up to 10 years. You understand that?
Your Honor, I think these would comprise his second and third technical violations.
Oh, I'm sorry, I forgot that these were technical violations. Okay. So you understand that you would not be subject to the maximum possible penalty on your underlying charge, but you would be subject to lesser penalties for first and second. So did you say second and third or first and second?
Second and third.
Second and third, so it would be up to 30 days total. Do you understand that?
Yes.
With that in mind, what is your plea to those two probation violations?
Guilty.
Okay. Has anybody threatened you with anything to get you to plead guilty to the probation violations?
No.
Has anybody promised you anything other than what we discussed here in court today?
No.
And is it your own free choice?
Yes.
Counsel, did either of you have an objection to the court using Mr. Pickett's testimony in the previous plea hearing to establish a finding of violation of probation?
No, Judge, I do believe for the record that it would establish the violations. Thank you.
No objection.
Okay, so the court will accept Mr. Pickett's previous testimony. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied based on his testimony that there is an adequate factual basis to support a finding that he did violate his probation as alleged at counts 1 and 2. The court will accept that plea as well. We'll set all matters for a sentencing hearing, and Mr. Pickett, you just need to meet with Ms. Davis before you leave the court this morning, okay?
Yes.
And then just make sure that you stay in touch with Mr. Trush. Do you have a good phone number for Mr. Pickett now?
Yes, he provided me a new number.
Okay. Mr. Roll, anything further on this file?
No, Your Honor, thank you.
Mr. Trush?
Nothing further.
Okay, thank you. That's all for today, Mr. Pick. That also concludes the court's morning docket. Court will be in recess until 1:30.